no big. All right, the breaking news that's coming in: the Supreme Court declines the pleas to seek stay on Waqf property. This is the big breaking news that's coming in as we are speaking, and it means this is a big victory for the central government. The bench had assembled. The Supreme Court has given out the judgment. As we are speaking, the Supreme Court has declined the plea to seek the stay on the Waqf Act. The Supreme Court stays. It says the provisions of the Waqf Act that a person should be a practitioner of Islam for 5 years to create a Waqf. The Supreme Court, the provision till state governments frame rules on determining whether a person is a practitioner of Islam. That's also coming ahead. The Supreme Court has stayed one provision of the Waqf Amendment Act is being said. This is the Supreme Court's interim order. Viewers, we're being told two kinds of things that have happened. Remember, this is something we are going to wait on. We're going to try and understand what has happened. I'm going to now tell our viewers what's happening inside the Supreme Court. The Chief Justice of India is speaking in the Supreme Court and saying, we have held that presumption is always in favor of the constitutionality of statute and intervention only in the rarest of rare cases. We have prima facie considered the challenge to each of the sections. We have found that no case was made out to stay the entire provision of the statute. So the big breaking news coming in, the Supreme Court says there is no way that we could have stayed the entire statute. However, some sections need some protection. This clause 3 subsection R will be stayed. That is, the clause shall be stayed on showing person practicing Islam for 5 years without any mechanism. It will lead to exchange of arbitrary power. The Supreme Court judgment is there. The Supreme Court is not staying the entire Waqf Act, but they have said presumption is in favor of constitutionality of statute and only intervention in the rarest of the rare cases. But the Supreme Court has stayed one bit of this.
Right. Rhythm, I'm coming back to you right now, but this is huge coming in. It's a big win for the centre. We see that the Supreme Court has declined the plea to seek stay on the Waqf Amendment Act and has granted stay on certain provision. The presumption of the constitutionality lies in favour of the legislation. Supreme Court grants stay on the provision of Waqf creation subject to practicing Islam for 5 years until rules are framed there under. So this is huge coming in, viewers. Remember that the Supreme Court was supposed to go ahead and give its interim order on 3 key issues, including the power to denotify properties declared as Waqf by courts. All right, let's go to Swapnil Kothari, who's joining us on the phone line. Thank you for joining us here, Mr. Kothari. And this is very important given the fact that this is also a big win coming in for the centre. How do you read this interim order?
It's a perfect shot in the arm for the centre. The centre came out with a very noble objective of the Waqf Amendment Act. It needed amendments. It needed to denotify certain captured properties, so to say. And that is the reason why the Supreme Court saw through that and understood that that was the real reason behind passing the Waqf Amendment Act, so that Waqf properties which are originally there, they need to be Waqf properties. And the ones that have been confiscated for beneficial purposes, just or under the garb of beneficial purposes, need not pass muster, and appropriate scrutiny should be there, and only then they should be notified as Waqf properties, or otherwise they should be denotified. So when I read the judgment and I say that they need to be denotified, that means that whatever is appropriate needs to be notified, but what is not needs to be denotified, which means that there have been several properties which have been notified inappropriately, because property documents need to be there for every single Waqf property, just like your house and an office which has property documents. So if there are not appropriate property documents properly showing the owner or showing the ownership as we use, or proper title as we use it in the legal parlance, then that is not going to pass muster, and that is the reason why the Supreme Court has passed this interim order.
Kapil, absolutely. The Supreme Court has, in fact, while staying this, also said, the Chief Justice, that there is always a presumption that we're not going to stay the entire law. The Supreme Court has only stayed the provision in the Waqf Amendment Act 2025, enabling an officer designated by the government to determine the dispute whether the Waqf property, Swapnil, has encroached a government property.
Well, there you go, Rhythm, right there. That's exactly what I said, and I pretty much knew that this is what the order is going to be, because at the interim stage, the Supreme Court is not going to say that the Amendment Act is unconstitutional. Number one, at best, it's going to stay, and for reasons for staying a central legislation which has a wide impact across the nation is not going to be stayed unless you show that it directly infringes the fundamental rights. It does not come from a statutory basis, and or the legislative power was not there. Absent these two things, the stay is not going to be granted to them.
Yes. And I just want to tell our viewers, Swapnil, before I come back to you, what has happened in the Supreme Court. The Supreme Court, as of now, viewers, the breaking news coming in, has only stayed the provision in the Waqf Amendment Act 2025 that a person should be a practitioner of Islam for 5 years to create a Waqf. That provision stayed till the state government frames rules on determining whether a person is practitioner of Islam. The Supreme Court, while passing this, has said we have held presumption is always, like Swapnil was saying, on constitutionality of the statute, and in rarest cases, a statute can be stayed. We found the entire act is challenged, but a basic challenge is only to a few sections, and we've gone to the legislative history from 1923 Act, considered prima facie the